Our next round of questions will begin with Mr. Murray. Approximately 95% of criminal convictions are obtained by guilty plea, rather than bringing a case to trial and a guilty verdict. Much of this phenomena is often attributed to prosecutors overcharging the cases, making it far too risky to plead not guilty even where the facts may not support a guilty verdict. Do you think it would be beneficial to have more questionable cases brought to trial rather than resolved by guilty pleas? If so, what would you do to discourage overcharging by prosecutors?
Well, first of all, I think, the right to jury is paramount. The right to have your case heard by a jury of your peers is a fundamental right we have in this country. If the defendant believes that the case should be determined by a jury, that's his or her right. I certainly believe in that. I don't, of course, would abhor overcharging somebody for something to get a conviction. That's wrong, and I don't think that should ever happen. So I'm not in favor of that. The question was a long one. I may have forgotten, but I don't believe prosecutors should overcharge to get convictions, and I think people should try their case to verdict if they believe in their innocence.
Okay, we're going to go this direction so that I don't make the same mistake.
Next? Okay.
Yes.
All right. As I said before, I do a significant amount of criminal defense. I think I am a great believer in the jury system, and I would never, ever, using that song, I would never, ever tell any of my clients to plead guilty if they didn't do it. I mean, if a person really claimed their innocence, I would take it to trial. I mean, no matter what. But the plea system is a good system, though, because a typical day, if you go to a typical common pleas judge criminal division, they may have 12 cases, and at the most, one will go to trial. If every case went to trial, the system would collapse. We would need, well, of course, it wouldn't be that bad. We'd have to have 100 judges, which wouldn't be bad. I have a better chance of getting the job, but it would, for taxpayers, wouldn't want to say. You would have to have instead. I think there's, I don't know how many divisions, I think there's like 15 judges in criminal. You'd have to have 100 judges in criminal division. You have to pay more for jury trials. I think that not having a plea system would destroy the system. That's my belief.
Ms. Arnsberger.
Well, it sounds from the question as though they're overcharging as a form of intimidation. I think that's where your discretion as a judge comes in, and you say, to prosecuting attorney, don't you think you're overdoing it here? I mean, you raise it with them before it proceeds further. I don't approve of something like that. I understand there's a great need because of the volume to push the system along, but you're really there to individually deal with each accused person and their rights, and you should not be. They should not be doing that. So they would have a hard time getting that past me, once I understood what they were doing. That's all.
Well, I think the overcharging is really an accepted part of life in the criminal division of the court. I mean, this happens. And you can chip away some of that at the preliminary hearing. And at the end of the day, if an individual wants to take responsibility and plead guilty for something they did, usually you will find the prosecutor is reasonable. In instances where a prosecutor is unreasonable and will not back off to anything that's acceptable to your client, then you go to trial, and you'll find that more often than not, you're getting a not guilty verdict. For 20 years, I've experienced that. So really, and the DA's office is very good also about working with you. Unless there's an individual DA that has a vendetta, and I don't see any of those particular people in this room, you will work things out. And the stop loss is the jury trial system.
I think for the same reason the last question talked about judicial discretion, I think a prosecutor has prosecutorial discretion, and you can't take that away from them. I just believe, and I've seen it in my own trial work, that the system has a way of equalizing, and that juries get it. And so the danger for a prosecutor who overcharges with an innocent defendant is the jury's going to see them. They're going to get it. So I have great faith in juries and the system to balance out what may be inequities at the outset.
I don't disagree that there's some element of overcharging that goes on, but I think that's just, I don't know that there's a relationship between the overcharging and the element 95% plea bargains if that's the case. I think ultimately in a case the facts bear themselves out and the client is faced with a deal and they can choose to accept it or not, and again, there's always the option to go to trial. So I just don't think there's a relation between the overcharging and the plea bargain. I think plea bargains are often done because they feel it's in their best interest.
I think this question is in part a question about resources, because it's been pointed out already. If we didn't have the number of guilty pleas that we get in the criminal justice system, if more people insisted on going to trial, the system would fall apart. So I think there's a resource question there that is worth thinking about further. What I will also tell you, I told you already, my expertise is in family law, children and families, and I think it is really important for a judge and a lawyer not to opine on things they don't know a whole lot about. And so what I would say to you is, I would look into this question further before giving you an opinion today on what should be done.
Mr. Tranquilli.
Well, I'm gonna sort of break ranks here. I'm gonna challenge the underpinnings of this question. I'll be honest with you. I don't know where the statistics are coming from, but I know that in Allegheny County during my 20-year tenure, I've seen very few incidents of overcharging by the prosecutor. You have to remember that the people that get the first crack at defendants are the police. The police charge whatever they want to. Then the prosecutor steps in and represents the case in front of a district justice. That district justice decides whether the case has been overcharged or not. And that district justice decides whether there's enough evidence to continue with all the charges or only some of the charges. So there's a safeguard built in there. For example, if you have a bar fight and somebody cracks somebody upside the head with a beer bottle and it cuts their head open, you can charge that as aggravated assault. It's also simple assault. Which one is it? It's up to the 12 people that ultimately hear the jury case. Okay? There are many cases like that. The difference between burglary and criminal trespass is just a question of intent, and the jury has to decide. As a judge, I can tell you I would not accept the plea unless a defendant told me absolutely after a colloquy that he was guilty of the crime he was pleading guilty to.
And I'll just follow up with that. I don't do a lot of work in the criminal division, but in the family division, juvenile court, there is a colloquy for a guilty plea for a juvenile. And assuming that would be the case in a criminal court proceeding, for an adult, I would be careful and make sure the person understood their rights and knew what they were pleading to, and there was a proper colloquy. These individuals are represented. They do have defense counsel, and if they don't want to accept the plea, they have every right to go to a trial and let their peers make the decision. I certainly wouldn't encourage any overcharging as a judge, but it's a process, and they're entitled to their rights, and it's also for the sake of resources. It's been mentioned by a couple of my colleagues that if we didn't have all of these pleas, we would have, the system would be overcrowded, we would have backlog. So it has some beneficial purpose, and of course, the victims' families would have to be obviously they're consulted as well, and it saves them the trouble of having a trial, going through some hearing of the facts of the case. Thank you.
I have to disagree with Mark somewhat. I don't think district justices have that much discretion in eliminating the cases. All that you have to show is a bare prima facie case for these charges, but I think the trial judge has to have the same reflection as the charges are brought to the common pleas court. I think that a judge has been referred to in a number of areas, expert witnesses and so forth, as a gatekeeper. I think the judge has to work as a gatekeeper on the charging, and if the charges are not warranted when it gets to the trial court level, I think the judge has to have the conviction to dismiss those charges.
My practice is exclusively criminal defense work, and I will say that I agree with Mr. Tranquilli that I think that our district attorney's office does an excellent job of not overcharging. In fact, overcharging to force a plea, I think, is prosecutorial misconduct. It's not something that happens. Of course, the magisterial district justice has the authority to throw the case out completely, but there are many safeguards along the way. I think part of the question at the end, and I don't really remember it, I think it said something about what can a judge do to keep this overcharging from happening.
Yes, it is. What would you do to discourage overcharging?
Discourage overcharging. And I would say two things. Number one, when they're answering the guilty plea colloquy, there is a question, are you pleading guilty because you are? And if they are not answering yes to that, the judge should not accept the plea. And secondly, I think it's important to start using the pretrial conference as more than just like a perfunctory date. And I think really having a pretrial conference instead of just picking dates, sort of getting down to the paring down the charges to what's absolutely appropriate. But like I said, I don't think it's an issue with our county's district attorney's office.
Okay.